Hey guys, and welcome to the weekly docket. Hey guys, good morning. Got some early comments in here. Let's hit those. Good morning to Oklahoma. Very cool. And the other Carolina, the next best Carolina, and Canada, which is its own whole country, keeping us separated safely from the dangers of the North Pole. And as to tough guy Tim Ferriter, we are going to hit him for sure in this stream toward the end of it. So let's good morning to Michigan, Dubuque, Iowa, and Indiana, which of course makes an appearance in this stream shortly in the controversial Delphi murders case. Let's see if I can get this up large enough, hopefully for you to see it and for me to read it too, since I don't have it open. Let's catch this. And good morning to Indianapolis. People from all over, which may be a topic I hit at the end of this too, for a particular reason. All right. So here we go, headed to Indiana and the Richard Allen case. Of course, he's charged for felony murder for the murders of Libby and Abby. And everybody agrees it's horrible and terrible, and everybody wants it solved. Not everybody sees this case the same way, of course. And the horror of it is, you know, you had the girls taking pictures and videos the day they were murdered. There's a picture there of Abby taken by Libby, and then also part of a video taken by Libby of the person who abducted them off the bridge. Just can't quite tell who it is, unfortunately, even though it has a voice and pictures. So, hello to Florida and to Boston. We're sunny and clear. Well, we picked up your weather for you because it's cloudy, foggy, and rainy here in Raleigh. Hi to Tampa. And do we think the Odinists did it? Well, some people do, and let's get into that. The ODIN Theory is going to be tested, is what I said in the summary for this video. And what I mean by that is the judge has, on her own motion, ordered the status hearing for October 19th and told the lawyers to arrange their schedules to appear. Judges do that sometimes. You need to get there, right? You can have other things. This is an important thing according to all the filings in the case, so get there. Purpose of that hearing is to discuss the upcoming hearing on October 31st and other matters which have recently arisen. I wonder what all that could be. So there is going to be a hearing on certain things, at least on October 31st. And I would think they'll get down to brass tacks on this Franks thing pretty soon. They already reached some level of decision on the discovery, with the judge ordering discovery to be turned over by November 1st. So if there's any issues going on with that, I'm sure that can be brought up at the status conference on the 31st. Hello to Frederick, Maryland, and Ireland, which is such a cool place. I've been there a few times. You can't outdrink the Irish, no matter how much of a redneck you are, I believe. And I don't mean that all Irish people drink, but I do mean that where I went, they did, and it was hard to keep up with. In Ventura, California, that's awesome. Glasgow, Scotland, a place we haven't been, but would love to go there. Wet and stormy Scotland. I mean, that's just a cool description of the place. It's how we always think of it. All right. So what's going on here? You can see a transport order is entered. So Richard Allen will personally appear at this hearing. Okay. And there's also correspondence too from the court filed, and it's noted as filed by Richard Allen. There's some question about who filed that. What letter is that? I haven't seen that, but I will say that everything filed by his side is noted as filed by Richard Allen. And if it's from the state, it's filed by the state. So I don't know. There was some talk about whether he sent a letter to the judge, and I don't know that. If he did, that's typically never a good sign. Shades of Sarah Boone, but I'm not saying he did that. So I think there'll be some information come out soon. A lot of stuff going on around this case, rumors of some of the evidence, pictures and things leaking out. Kind of hope not, and just for everybody's sake. But let's see what we're going to be talking about, at least for some of this stuff, and how at least my opinion works on it from what I've seen, which I'll show. Credit to the defense here that the Odin situation is pretty popular, more popular than I certainly would have guessed, as it comes out through the filings that the two guards were involved in Norse pagan heathenry, which isn't necessarily Odinism, right? Not that I'm any expert on it, because I am not, but like most things, it's not just a one unitary concept. I mean, you can be a Christian, you can be all these different things, right? Same thing for Muslims too, right? Well, apparently that's true for this stuff as well. Now, I got to admit, where I'm from, I kind of envision if I were going to be in this Norse stuff, I would imagine myself like these people on the top row from the Viking show, but I have a feeling a lot of them are like the people on the bottom row. So I don't think it's as cool as maybe it sometimes is made out to sound to be to people who want to be involved in it. So I don't know about that, but credit to the defense that they said that their guards were involved in Odin, and maybe they weren't involved in Odin necessarily, but they are involved in this Norse pagan heathenry. Now, whether that sustains any of the inferences and statements that the defense makes based on that remains to be seen, and how it can be relevant to Frank's hearing is also up for debate. All right. So what is this about? The defense has filed this motion for Frank's hearing, which is that they want the search warrant for Allen's house to be invalidated, his house and his vehicle. It's not a motion to dismiss. It's not a trial of the case or something like that. It's really to invalidate the search warrant. That's a pretty limited purpose, right? So there are two things you have to do in a Frank's hearing. I know we're going over it, but it sets the stage for what we'll talk about. You have to show this material lie, okay, the reckless disregard for the truth, or perjury, that's a material lie. But if you do that, it doesn't mean, well, law enforcement lied, so this warrant is out. You might think that, but that's not what the case says. The case says also, if you do that, then the probable cause affidavit cannot, if you take that lie out or put the information in, then a judge would have found no probable cause and wouldn't have issued the warrant. So the first thing the judge is probably going to do is look at what's alleged that the state supposedly lied about or materially left out. And the judge will say, well, if I had known these things and I were the one issuing the warrant, would I have carried on with probable cause anyway? In other words, would the affidavit support probable cause if you struck out the lies or added in the other material? You assume that's true first, just to see whether you even need to have a hearing on whether this stuff happened or not. That's why I say that the material points that the defense brings up is the issues on the timeline. Now, that's not to say that's substantial enough to throw out a warrant, but they do go to the things that the state said justified the warrant, right? If they lied materially about the timeline, the judge should look at that, or, the allegation of that, and see whether that would be enough to remove probable cause. But the real thing, of course, in this motion they filed was this 90-some pages or 100-some pages about the Odin stuff. And the idea is whether an alternate actor or theory discussion is required for a search warrant. Is that really going to set the stage for a Frank's hearing and then potentially to throw this warrant out? And that's interesting, right? So I'll tell you what I think about that. And, the judge has some leeway on this. First of all, it's the judge's decision. And second of all, it can be appealed. So here are some cases from Indiana talking about Frank's hearing. And they say the United States Supreme Court held that when a warrant is supported in part by perjured statements or statements made with reckless disregard of the truth, the warrant will be invalid if the remainder of the supporting affidavit does not contain a sufficient basis for probable cause. And we will presume that the search warrant judge's determination of probable cause is valid. This is Indiana Appellate Court. It's not my opinion or somebody else's opinion. This is an opinion that actually matters. They have also said a warrant is invalid where the defendant establishes by a preponderance of the evidence that the affidavits used to obtain the warrant contain perjury by the affiant or reckless disregard for the truth, and the rest of the affidavit does not contain material sufficient to constitute probable cause. So you can imagine that if the prosecution had written into their affidavit, hey, early in this case, we thought about whether this was a ritualized crime. We even had some discussion from the FBI about it. We decided there was no way to really conclude whether it was or staged or believe that. We looked into some people. We found they had alibis. We ran down that rabbit hole. And we just didn't think it worked out. And we're after this guy. If they had told the judge that, would that make any difference on whether the judge would have issued an affidavit on Allen or not? I think people are caught up in like, this is really important. They should have told the judge. And for a Franks hearing, let's assume that's true. Would it have changed the judge's decision for probable cause? Or is the judge going to, try the case and decide whether the police were right or wrong about what they thought about people's alibis or credibility of witnesses? And that seems very thin to me. Good afternoon. Back to the UK. So that's the intellectual framework of the motion, I think. And the idea is, does a search warrant require discussion of other suspects and theories? Okay, because they're outlining why they think there's probable cause to search Richard Allen's house and vehicle. And the defense does say that they misrepresented things about that. And that's why I think that's relevant. That's not to say it decides the motion, but it's relevant to what Franks is about. But this idea that they should have discussed a particular line of theory about the case or other suspects, I think you go down a rabbit hole there that's not required by Franks. And here's why I say that. Before this Odin thing came up, there were a lot of people who believed that the Kleins were involved, right? The son, the father, or whatever you want to pick there. The son was connected to the girls just before the killings because he was running this Anthony Shots account. And that's true, right? He may have been one of the very last people to talk to them. He left town shortly after that, he and his dad. He is a pedophile, right? Members of his family have some bizarre history that's not entirely lawful. Rumors about his Jeep being near the area. Those are all, I think, reasonable things to consider whether this guy had something to do with it or not. Certainly I wondered that, because it's like, was this really random that this guy was on this bridge when these two girls got there and was ready to seize them? Or did the person know that they were coming, and who would have known, well, here's this guy running this catfishing account or whatever to lure the girls there. And, is the idea there. I still don't dismiss all of that entirely. Maybe somebody else had access to that account or not, but I just don't know. So should a judge have given or been provided with by the police 50 pages of discussion about how hard they tried to connect Klein to this crime, right? Because they interviewed him, they looked at things, they searched in rivers and stuff like that. And where's all that in the probable cause affidavit for the search warrant? So you got 50 to 100 pages of that, I guess you should put in there. How about Ron Logan? Okay, people called in and said, hey, that's the guy on the bridge video. That's him. To me, that's him. And a lot of people still believe that. And that's understandable because there are great similarities there. The girls were found on his property. He was violent towards women, had a history of that. He lied about his alibi, okay, where he was and when he was there. His phone pinged in the area somewhere around the time. I think a search warrant was even issued against him. So 50 to 100 more pages there for the judge to look at and think hard about, before I let you have the search warrant for Allen, I really want to know more about this Ron Logan and Keegan Klein and Klein's family. And what about other people at Logan's house? And there are no shortage of sleaze bags around that town, apparently, which is one of the things probably makes this case so hard. Here are a couple of people down at the bottom who were considered in this case, and look how similar they are to the sketches, which is one of the problems with the sketches, is they resemble a lot of people who are in that area. And these two dudes right here would be good candidates. I'd say another 50 pages each, if you're going to get a search warrant on anybody. So as the case evolves and you get 10,000 tips, the search warrant application would need, for anybody else, would need to become like 500 pages long or something like that, because you really need to prove to the judge why you ruled out all these other people before you get this search warrant. Now, I understand, what's interesting about the Odin stuff and the crime scene and everything like that. But my point is, does a Franks hearing require the police to talk about the other theories of the case that they've already run down, whether they're right or not? Okay, because we're just talking about the search warrant. And interesting that they need to get this, the results of the search warrant excluded. They're doing the right thing there. But, what did they find there that they need out? Well, the gun, right? And we don't really know how tightly that connects Allen to the actual crime, but we know that's an issue, and they would like that gun taken out because it would remove the bullet evidence, which may ultimately be nothing, or it may be very weighty. That's going to be up to the jury. I think it would result in, if they were successful, that they would then end up attacking the arrest warrant because it had the gun in it, and they probably try and attack the confessions, but some of that stuff would not be successful. But really what I'm talking about intellectually is, does it, when you apply for a search warrant, do you have to go back through 5 or 6 years worth of stuff, pull out everybody, or just retrospectively, the defense can say, well, they should have at least talked about this one person. Really, what's the standard there? How come you can't pick out one of these other people and say you should have told the judge about Ron Logan? Why didn't you discuss that with the judge? It's his property. People called him in. He's past violence, lied about his alibi. You didn't tell the judge about that. So I just don't see a new standard being created where you have to give an entire history of the case. I just don't think that's going to fly. But, you know, who knows, right? It's up to the judge to decide it. You know, earlier in this case, this was a chart I made when these were some of the prominent people who were considered potentially involved in this crime. And it's one of the clients up at the top, and then Ron Logan, right? Okay, because he could look like those sketches if you wanted him to. And Richard Allen, and then also who knows, which right now I guess you could put the Odin people in that box. For sure, right? Because that's what the defense is telling you. That they're not saying Klein did it or Logan did it. They're saying these other people did do it. And, you know, I've also been told with great certainty that some of the people who certainly weren't Odinists, who were on the bridge later just walking that day, this guy did it. That one of the girls' families was involved in it. Certainly, absolutely was involved in it, of course. The defense isn't saying any of that, but still, should the judge have been told all these crackpot theories and all of that? I don't think so. So I think I've already mentioned the first bullet point here is, do you discuss every theory where somebody was considered, each theory of crime motivation, how you ran all the leads down, how you checked the alibis, whether you thought the information was credible? Is that really the standard for the search warrant? I don't think so. I think what they brought up about the actual information provided to the judge for probable cause and whether it was wrong, okay, on purpose or whatever, or they omitted things about that were material, like, you know, descriptions or Allen's later story or something. Yeah, it's interesting. That's really what the Franks hearing should be about, okay, if you're going to have one. So it's not a trial. The Franks hearing is not a trial. It's not a discovery dump, right? But I've already seen people prepping this on Reddit, you know, that if the judge doesn't go along with this and, you know, toss out this search warrant, then she's in on it. She's lazy. She's dumb. She's already been called those things because she hasn't sprang to attention and done everything that the defense wants. So now let me say this here. I would need a lot more proof of guilt before I would convict Allen. I was always suspicious of the Logan guy. That's an absolutely reasonable position to me. I mean, it's absolutely reasonable. If you and I we're in a room right now as jurors on this case, and you said, I want to vote not guilty right now, I would completely concur with that. And even though I'm on the side of thinking they probably got the right guy, but we haven't really seen the evidence yet or the case actually in court presented or challenged. And the thing about Logan and Klein and some of these other guys is there are scumbags just circling like sharks all around that area. And it's hard to pick just one of them out. So I hear you on that. And I think there's nothing unreasonable about that. This is just about whether the search warrant should be invalidated or not, based on the police not telling the judge the whole history of the investigation. And I just don't think that's going to happen. Could the search have excluded him if nothing had been found? Well, that's a good question. And thanks for that super chat or whatever they call it. And let's say they didn't find the gun there and stuff like that. And would they have proceeded with the arrest immediately after that? You know, I don't know, because they did find the gun and they claimed to have matched it. You know, again, the weight of that, subject to great debate, right? I concede a lot of points that people have about challenging that. But it is evidence that can be admitted. So you have to understand it. It can be important at trial. I don't know that there's something there that could have, say per se excluded him, because how can you prove that negative, which is one of the problems the defense says. Okay, he was there that day, and if that's all you got against him, how are we going to prove he didn't kill them, right? Other than showing the crime scene and other things like that. And that's not their burden. So I don't know that there would be something there that would exclude him unless they found something there that actually showed somebody else did it. But finding nothing in the search warrant would have harmed their case for sure, because they have the circumstantial timeline, and without anything from the home, that's all they have. They just have any physical evidence. And all they do have, to my knowledge, because I think similar clothing won't get it unless you can, find some blood or something on that clothing. A lot of people have blue jackets and stuff. I really think what they got out of that so far is that gun and the bullet match. And whether that matters or not, ultimately, we'll have to see. So I think the answer to what you're saying is no, but I think if nothing had been found, I don't know whether they would have arrested him at that time or not. I just, why would you, if you didn't find anything, you might have continued to investigate. Remember, they were searching that river and stuff, and I think most likely that was related to Klein. So I think it's fair to say the state wasn't certain at certain points of who to go after, really. And then their own ideas that more than one person was involved in that. And that's one of my issues with Allen, is if more than one person was involved in this killing, who was it? Like, who did Allen have a relationship with that he would participate in killing two girls with, or somebody else for that matter? Because it's one thing to want to kill people, and it's another thing to have a buddy that you share this interest with and trust enough that you're going to do it with them. And nothing about that has come out, but the state itself said they think there was more than one actor involved. And there's that whole Anthony Shots thing. So it's a confusing case. I'm not going to say there are no points for the defense, because I don't think that at all. So Bridge guy looks more like Logan, in my opinion. And I hear you on that, right? I don't agree with the people on the internet who've like draw lines on the screen and say it proves that it couldn't be Richard Allen because of how tall and stuff. That's really sloppy. If it were that easy, the defense would have brought it up. Maybe they will later. But yeah, I mean, if you were to put Logan there and you had other evidence against him and you said that's that guy, I'd be like, oh yeah, it looks like him. I think one of the problems is a lot of those guys superficially look like each other. Okay. So something fishy in Delphi are just crappy police work. I don't know the answer to that. If in fact Allen did it, then, you know, losing his tip or whatever for 5 years, then finding it later is certainly poor police work. Because I believe the officer who talked to him was on the stage at one or more of the press conferences with some of the other team that were trying to investigate this case. How does this not come back up? Even if Allen had, say, a rock solid alibi that he didn't or whatever, do it or whatever, he's still like a crucially important witness, kind of like the three girls and stuff. Like, how could you not have gone back to him and talked to him again later? So that's a fair point. Yeah, once he said he was on the bridge at that time and he was wearing all the clothes, that did it for me. And I hear that, and I guess what I'm saying is I kind of agree with that from the standpoint that that situation of him meeting those girls at just after 126 when they took the picture at the bench, and the girls had been on the bridge earlier than that. I actually took a picture at 12:43, the three teenagers plus I think a younger one. And then seeing him at 1:30 puts him coming onto the trail around that time and them leaving around that time supports what the officer said, that he was on the trail between 1:30 and 3:30. I think that looks really bad for him because he's the only male seen there by himself, by those three girls, and then by the adult witness who comes onto the scene only minutes before the girls are killed and actually sees the two girls. So that's a pretty strong circumstantial timeline. And the defense attacks on that, I think, are appropriate for a Franks hearing. They don't persuade me, but they're appropriate because that's what they were using for probable cause. If they found the gun, wouldn't they be able to match the gun markings to the gun is the comment here. So they found the gun, but remember, a gun was not used to murder these two girls. A knife was. So what was found at the scene was a .40 caliber round that had not been fired, but had been chambered through the weapon. So it can be the case, or is the case, that when you put your cartridge into the gun and you cycle it, it's going to get scraped up and marked because the extractor has spring tension on it. You may not see it with the naked eye, but it's going to mark it up at least to some degree microscopically and stuff like that. Then it goes to the lab and you take his gun and you cycle it through and you set it down with an examiner who looks at the two and decides, I think this is a different gun based on the marks. I think it's the same gun based on the marks, or I can't tell, is kind of what they do. And a lot of people criticize that and say, well, how do I know that if you didn't have the next one that came off the line, SIG 226, it wouldn't make marks that look similar enough that you would reach the same conclusion, yet it only could be one gun, not two. That's a fair criticism, I think. Now, some people think like this is so different than when they match projectiles, actual bullets that have been fired. It's not different, okay, because it's tool mark analysis, because what happens is the bullet goes down the barrel and it is pressed against the side of it, okay? And so as guns gets older, you shoot more. Sometimes you have to use more gunpowder to get the same speed and stuff like that as it wears down. It's a lot of friction going on there. And the bullet actually is marked by the rifling, okay? So then they'll shoot a round through the gun that's a subject, and then or more than one, of course, and they'll compare it to the rounds that were recovered, and they'll say the same thing. I think this is the same gun that fired these bullets, a different gun, or I don't know. That's tool mark analysis. So if you don't trust the cartridge stuff, then you can also not trust the bullet stuff. Now, I think it is fair to say that the bullet stuff is more pronounced. I mean, anytime you pick up a bullet that's been fired, you can probably going to see rifling marks on it. And it's harder to see the extraction marks. But they really shouldn't just be eyeballing it. They have to put it in our microscope and look for what would make it distinct. And so if you're not using a microscope, you can't really say how well it matches or not. This is why I think this evidence could amount to nothing, or it could be very bad for him. Part of that depends on how persuasive the examiner is, because that's the opinion that's going to be given, is the examiner's opinion. How good the cross-exam is going to be, whether they have an expert that can debunk what this person is saying, because you have a piece of physical evidence recovered from the scene. They're going to attack how that evidence was recovered and stuff like that too, of course. But I'm talking about the match itself is subject to opinion. It's not a computer spitting out an answer. It's a person looking at them and based on their training and experience saying, I think this came out of the same gun and here's why. Well, if you were going to look at that, wouldn't you want to see that? Like if you saw somebody to match fingerprints, you'd like to see blown up fingerprints, oh yeah, I see what you did here, right? I see where you match these elements of the fingerprint, stuff like that. You'd want to see that. And it's hard to say what's going on here because you don't know if Allen's weapon had, for some reason, some issue with the extractor that makes a very distinctive mark or not. I can't assess it. And that's why I say, for one, I certainly wouldn't vote him guilty right now because I don't know the quality of this evidence. But if the match is high quality, that looks really bad for him, right? Now, he's not the only person on the planet with a 40 caliber gun and stuff like that. So it's not all by itself damning, but it looks bad for him, and it would certainly help to establish probable cause for his arrest. But if they didn't have the gun, they would never have been able to match up the bullet. So, you can see that they want a domino effect here. They want to attack the search warrant. They recovered the gun. Then I'm sure they want to attack his arrest. They want to attack his confessions and things like that. Yeah, I think people are getting confused about this. RA's only charged for leading him to the death, not the one who killed him. Totally different charges. And that's true. He's charged with felony murder. So all they got to do is show that he abducted them off the bridge. And that's good enough, because that certainly led to their deaths. Not even the defense is contending otherwise. Now, there were nuts that contended otherwise, that, girls were transported to some other place and stuff like that. But the defense has not contended that. But I think it is a fair way to assess the case, because the state themselves are putting him on the scene of the murders, right, with his bullet. So that's part of saying that he was there, okay? Not that he killed them, okay? That's not, as you say, that's not what's really at stake in the charges. Now, that's helpful. If they were to find out he did it, that would make their case a lot easier. But what they really need to show is that this was the guy on the bridge who abducted them off the bridge. And then that's going to be good enough for a conviction for him, if that's true. But it conceptually makes sense to me that if the state itself is saying that you have more than one actor involved, then it stands to reason that Richard Allen is working with someone else by the state's own admission or contention. So who's this other person, and what's the evidence he had a relationship with somebody else? Now, they don't have to prove that, but I think that's a low spot in the case for them. So the evidence that he's the guy who abducted them really is his presence on the bridge at that time, the circumstantial timeline that appears to exclude other males coming onto the trail at that time. So that's him, okay, at the time that they were abducted. And then the physical evidence is this round. And then another thing we don't know is what incriminating statements he made to his wife on the telephone later on, that, the defense is saying that the Odin guards kind of probably influenced him to that, but we don't know that. We also don't know what he said. That might be the worst evidence against him, or the confessions he made. So I've seen that most studies have been done on fired rounds. Yeah, I mean, that's, usually if the gun's used to kill somebody, then you recover that round and you recover the firearm, and you're able to make a comparison. But it's frequently the case too that that cartridges are also examined, and they don't get the limelight if the murder weapon is actually the firearm, because the round will be that, right? Because that's, if you charge a murder, you want to show that bullet came out of the gun you were firing. But fired case cartridges and unfired case cartridges are subject to being presented in court as well. They have in Indiana, and the court there has allowed that evidence. So they're going to allow it again. And, assuming that the basis is met and stuff like that, it'll be up to the jury to decide whether they're persuaded by it or not. Makes me wonder if they're actively looking for other possible participants, is the comment. Well, I think they kind of said they were, right? That's one of the reasons why they want some of these documents sealed early on, the probable cause affidavit. And I wondered what was in it. And then ultimately we saw what was in it. And it didn't show anything about another actor, right? It didn't have a clue to another person that I saw. So if you were considering anything in that for multiple actor, maybe the only thing you were trying to hold back is the fact that you didn't have anything in there pointing to them, because if I were the other actor, I'd be a little bit relieved by that. But good point, though, I think. And if they thought he was working with somebody else, they probably hoped that he would tell them or reach out for some plea deal or whatever like that, especially since, they haven't charged him with murdering. They've charged him with felony murder. So he's the one who abducted them off the bridge, and that led to their deaths, which is basically murder there. But different ways to prove it, different elements. Now, having said that, that's if I missed anything there. Having said that, if I'm right and the judge sees it the way that I do, that, hey, look, for Frank's purposes, I'm not going to be inquiring into how many people the police looked at and running down all their different alibis and things like that. Talk to me about what amounts to the probable cause in this affidavit and how the police lied about that, or what they left out about this timeline. If the judge were to do that, that doesn't mean later on the defense can't bring this up, either the Odinist or somebody else. They can't just, assuming that the judge operates normally under the law, they're not going to be allowed to just stand up and start naming other people. They have to show a connection to the crime, an actual connection to the crime, some kind of way that a person is connected to it. And then the defense can bring that up because it's relevant to whether you did the crime, if somebody else did it or not. And if they have evidence that somebody else did it, and you can show that that person did it, and Richard Allen never knew those people, wasn't delivering these girls to these people, that may come in at trial. I don't know whether they're going to be able to do that or not. The prediction I will make is that if it ever goes to trial and the judge doesn't allow this in, then the judge will be accused of being in on it, corrupt, lazy, dumb, whatever. As that seems to be the answer, rather than understanding that a judge can see things more than one way. Sometimes it's a judge. It's not a machine. A lot of times I see when talking about cases that as a case moves through a process, sometimes we'll have rulings for you or against you. And you'll see a lot of people that when they get a ruling against the side, they support the judge is corrupt, this is terrible, and all that. And then that flips when it goes the other way. Well, sometimes judges are wrong, but sometimes they have a range of discretion for what they're letting in as evidence in a case. And it might be a different view than you have. And, that stuff can be appealed. So if they're really wrong, they have a chance to recover it. Good morning to Utah. Spent a lot of time there back in the past. And thanks for becoming a member. Try not to miss those. There's stuff in the member section that you can look at. That's content that people voted to have made. Believe it or not, that's true. All right. I think the judge is like a parent. If both sides are complaining, you're being fair. And, to some degree, that's true. Sometimes people don't really complain about it. I think if you're talking about not the lawyers, but you're talking about people who are watching the case, and then I might definitely hear you on that. It's also, some of these legal things are tough to deal with, because you'd like to skip to the end of the book, right? And you'd like to say, is Allen guilty or is he not guilty? And if the theory is the Odinist did it, and you see that path, then you're going to say, well, he's obviously not guilty. He's either actually innocent or they can't prove the case. But a Frank's hearing is not about that. It's about a search warrant and whether there was probable cause to search a house and a car. So let's leave Richard Allen alone for a few minutes and head off to some other cases. And here's Kouri Richins. She's super stoked and happy in this picture, but I don't think she's smiling as much lately, as she's taking a little bit of a beating in court, and probably deservedly so. She has filed a motion to dismiss due to prosecutorial misconduct, and it doesn't involve Odinist or Tiny Ninjas or anything like that. It involves the walk the dog letter, which is in its own way equally strange. Here's some excerpts from it. Walk the dog, but take vague notes who you remember. And this isn't the first part of this letter, but it's one I wanted to make big enough that I can make sure I read it. Here she is, not acting suspiciously at all, by telling the recipient, remember I told you one way to get at Katie is going through my phone and finding a picture of her girls, even with the boys, print 15 copies and send them out anonymously to different media companies. Obviously, don't email the picture so it's not traceable. She would be livid if it got out to the public. You have to do it sneakily and be careful. Don't let her trace back to you. There's the words of an innocent person right there, not somebody trying to manipulate the situation at all, right? Other parts of her letter include suggesting the testimony of somebody and what they should say. And she starts off on it, upon information and belief, just like they say. They, I guess, being lawyers. And then she gives this narrative and helpfully allows that the person can, reframe it in their own words, as long as they make all the points she says. And she says, it can be shortened to the point, but has to be done upon information and belief, LOL. So the prosecution didn't like her writing these missives, directing people how to testify, or strongly suggesting or begging or whatever, however you want to characterize it. That's what it is. And so they filed papers about it. And her side says, oh my God, I can't believe you did that. You've compromised her constitutional rights, and this entire murder case should be thrown out, right? Sometimes the victim or victims are completely forgotten in this, and people want to look at like any technical default by the prosecution should result in this person strolling free and tiptoeing through the tulips without a concern in the world. And there are balancing interests in here, and you don't want murderers to go free. So you don't look for just they misnumbered a page or something like that. Now here, what they're saying is that she was accused of witness tampering. She's never been charged with witness tampering. How dare they say that? I think they actually say here, this is the defense paper here on the screen. The opening sentence of the motion states a no contact order is necessary to prevent defendant from further engaging in witness tampering. And they hate that. And they say the fact that it's got out into the public has tainted her trial. She can never get a fair trial for this, right? And so it should be thrown out. No, I don't agree with that at all. To me, that what she was doing obviously was trying to influence the testimony of somebody, which is tampering with it. That's my opinion. So they cite some things about the heightened ethical duty of prosecutors and stuff like that, and they can't make extrajudicial statements that influence the case, but this was not extrajudicial. Then they cite a rule that says you can't use the fact that you can file it in court as a reason to get around the rules, just doing it solely for that purpose. This obviously isn't solely for the purpose of trying to taint her trial. She was writing this walk the dog letter, and they want her to quit doing it. But yes, she should be allowed to roam free across the countryside, flipping houses as she wanted to do. So yeah, I don't agree with that. And I suggest this sequel to her book, Argue With Me, and it can be called Are You Guilty? And it can just be one page with it being yes, the end. All right. How about our friend Bryan Kohberger out in Idaho? I said a nothing burger on that. And here's a court order about some of the, the explosive charges about the grand jury shenanigans that the state was participating in, because every courtroom in every county and every state around this entire continent that's all crooked, and they're all in on it. But sometimes that's not true. And here the judge says, Judge is his name, as articulated on the record, the issues raised by Kohberger do not constitute a substantial failure to comply with the procedures for selecting a grand jury. And they say they either fall outside the code or are typical problems seen routinely in selecting juries. Somebody fails to appear and stuff like that. And some of the things in that were, oh my God, this page number was wrong on this form and stuff. So that didn't really go very far, did it? Not every argument is a winner, and there are a few losers on the Kohberger side. Here are some of them, in my opinion, that the allegation was that the prosecution misled the grand jury. And when you got behind the headline of it, because that's terrible, right? But you got behind the headline of it, and it was because the prosecution was informing the jury that you have to find probable cause to return an indictment. And the defense said the appropriate standard for an indictment to even face trial should be a finding by the grand jury that this person is guilty beyond a reasonable doubt. Does that make sense to you? And they even said in their own motion, the entirety of Western jurisprudence is against them. So I don't think they're going to win on that. And I don't think you have a beyond a reasonable doubt standard before the trial, or why would you need the trial? Because if it's beyond a reasonable doubt, then that means no, you don't need to hear anything else about it. Another red herring award goes to the idea that the family DNA tree, if they get the evidence of that they want, that supports the other circumstantial evidence of Kohberger being at the scene, is somehow exculpatory. That the DNA on the sheath was planted there by tiny ninjas or people whose papers he graded, who then later transferred his DNA onto the sheath. I did a pretty good long video on how DNA works and studies on transfer of it on trace DNA. It's also called touch DNA. I think it is more fair to call it trace DNA because it can be transferred. Went over a study of that from the handling of knives and stuff like that. So that's a good argument to bring up, but I don't think it's going to go anywhere here. Driving around the middle of the night is his alibi, and not remembering where you're at while you did it. And I guess having your phone off during the period that you're driving, that's a rock solid alibi right there. So these are non-winners, in my opinion. Maybe he'll come up with something better than this. While we're out there, here's a Chad Daybell and Lori Vallow Daybell. And how courts work here is giving an example here of Lori Vallow saying, we can't have cameras in a courtroom, bro. It's going to taint my whole situation to make the trial unfair. Chad Daybell is saying, I got to have cameras in a courtroom. I'm not going to receive a fair trial if I don't have cameras in a courtroom. And of course, Richard Allen is now wanting cameras in a courtroom. So, the state and the defense flip-flopping back and forth on who wants cameras and stuff. It's an interesting pickle. I don't know what you can say about that other than it is up to the judge, usually where these things are allowed. But it shows that lawyers will fight over anything if you give them the chance to do it. Mrs. Southern-in-law has alerted me orally, if in case you heard that, that there is a super chat. So let me check it out. Do I think Kohberger case will ever make it to trial? If so, when? How do you see this moving forward? Well, I don't know. If I were the defense at this point, unless that something good was offered, I might wait to see the results of some of these motions, right? Because if you were going to be successful, say on get the DNA excluded or something like that, then you'd have some leverage to the state. But I mean, I think it's pretty clear he did it. I know everybody doesn't share that opinion, but let's say you're on the defense team and you don't have to think that he did it, but what you do is realistically agree with yourself mentally and the rest of your team that their case is strong, right? Maybe they don't think that, but if they do think that, then at some point you're going to reach out to them for a plea. But I can't see the state agreeing to anything here ever other than maybe taking the death penalty off the table, because that hardly ever gets exercised anyway. And then nobody has to come to court and testify and relive all this stuff. That's usually the benefit for the state for that and the victims' families and stuff. Because some of them are very outspoken that they don't want that. They want this. They want him to face the ultimate punishment. So I don't know how that's going to go. I mean, the case is probably going to be delayed here and there, and that the speedy trial thing is off. Will it go to trial though? The house odds are always that the trials don't happen, that a plea is reached. But some of these high profile ones that you see, like even this Tim Ferriter thing that we'll talk about, which is bad but less serious, it ends up going to trial due to this guy's theory that I guess he's going to get off or whatever. And I don't know what Kohberger thinks about all this, of course, right? This is assuming he's guilty. Does he care? Was this all part of something he wanted to experience in his life, and the trial is maybe something he also wants to experience? I have no idea what this guy's thought process is. Going to jail for life is not appetizing, and maybe he would rather throw the dice and gamble against the death penalty and maybe get off than take life in prison for the whole rest of his life. In my opinion, while people see this differently, when he's shown up in court, he's been cool as a cucumber. If he were my client, I'd want him to behave like he is. I know some people think he's suspicious when he's appearing, but he seems aware, respectful, appropriate while he's in court. Okay. He had his issues, of course, in behavior and stuff like that, but he knows he's a smart guy, and I think he can play the role when he needs to. So I don't know what to say about it. I would think in theory it shouldn't go to trial. But in order for that not to happen, if you're the defense, you have to have the death penalty taken off the table. So I think we'll probably see some more motions practice and decisions and things by the judge before we get more of an idea of that. I mean, sometimes you even get in the middle of a trial and you work it out, but we'll see. And thanks for that super chat. I appreciate it. His alibi was so weak. Yeah, my alibi is, in fact, I was out driving around late at night, and I don't remember where. That's not really much of an alibi there conceptually at all. But what it does do to me is indicate that they know that video from where he lives of his car coming and going is highly persuasive. Now, they may want to argue that some of the video found closer to the murder scene doesn't necessarily show his car or whatever. But I think they are going to have to admit they're boned on him leaving and coming. In fact, they already have admitted that, at least in terms of the alibi notice. But I think his phone was turned off, so even if he drive around at night to relieve stress or whatever, is he going to turn his phone off there? You have to start stacking up a lot of assumptions in his favor to get past the obvious evidence in the case. Not everybody who's charged with murder didn't do it. Well, you can be as late as you want to be, but thanks for coming. And for everybody who's late or whatever. I mean, we are running a little ragged ourselves because we just came back from the Smoky Mountains. As people who watch the channel know, we were up there walking up and down the mountains, testing ourselves before the winter season arrives. I think that's just his demeanor. He's cold and calculated in my estimation. Yeah, I agree with that. But, to take another extreme example, let's take Taylor Schabusiness. She's the opposite of how you want your client to behave in a courtroom, right? And Kohberger, I think, is more like it. He's neat in his appearance. They've got him in street clothes, wears a tie and stuff. He's not looking at people weird. He's not staring at victims' families. He's answering the judge clearly when he's required to do that. So, I think he's a cold-blooded murderer. That's my opinion. But if I were defending a cold-blooded murderer, which I wouldn't want to do, I would want that cold-blooded murderer to behave like him until I got the case resolved. That door cam video and audio is a bit eerie. It is. I mean, and it's all so awful that somebody would do that. And I get the idea that he couldn't do it by himself because it happened so fast. But I don't agree with that. I think that's just an assumption, and there's certainly no evidence that one person couldn't have done that. I think if I'm going to imagine and make my own assumptions, I don't think whoever entered that house at that time, whether it was him or somebody else, was planning on killing 4 specific people and leaving 2 there. That doesn't add up to me. I think there was probably a target, and the scene unfolded how it unfolded. That's what I think. Do I think the leak from the grand jury is real? I don't know. There's issues about that in that case and some other cases too, about whether people are talking about things that happened in the grand jury that they shouldn't. And that can result in penalties for the grand jurors, of course. And I know there are some people out there, they're always waiting for a case to be dismissed because, this violation occurred, but I don't think it would result in anything like that. So you can swear people to secrecy and you hope they do that. And often they do, but it's not impossible that somebody said something to their life partner and then that life partner tells somebody else. And before you know it, it's out there, or it got telephone tagged to where they said something was inconsequential and then it gets amplified. It's really hard to say. Yeah, and here's somebody saying about this idea of having the trial or something. He's enjoying the process. It may be, right? I mean, I think it's a long shot, but my point is, I don't know that I could put myself entirely in his mindset. I did take his survey before they took it down about asking people to report in if you'd committed some kind of heinous crime, what your thought process was. I did it because I wanted to go through and see what kind of questions he was asking, what he was interested in. Obviously he had an academic purpose for that, but still the mindset is to some degree in there. And I agree that, that it's appropriate to understand the criminal mindset, of course, if you're going to study that and you want to pursue the career in it, stuff like that. It's just still, it was quite interesting to me that he was asking, what made you target this person? How did you feel when you were doing it? Those are all kind of interesting things, but are you going to get quality data from an anonymous survey doing that? Like I could fill it out and I haven't done any of those things. Are you kind of more expressing your own interest? I don't know. When I was an undergraduate, I worked with the Chapel Hill Police Department, did a study, people who had been victims of home crimes, burglary and stuff like that. We were really interested in how that mentally impacted them going forward. But I wasn't asking the people who did it, how good did you feel while you were doing it? Again, that can be very relevant if you want to deter people in the future or maybe figure cases out, stuff like that. So I'm not saying it's terrible, but I did feel like when I was taking that survey that it seemed to me it was more about his mindset than the information that he might gather. But that, I'm sure I was just putting that onto that and because of how I already thought about this joker. Okay, yeah, here's the thing about Chad Daybell wanting cameras. Is he going to get that? Yeah, I don't know about that. The judge seemed to like how it worked out last time with the audio. Probably do it again. That seems to be how they want to do it. So I kind of doubt it. Now, I'm going to go the opposite direction here and not just poo-poo people who say that the state frames people, and it's not that the state is always covered in glory. So we're hit the other side of this equation here. So here's a picture of a judge here, witness on the stand, clerks, stenographers, everybody doing what they're supposed to be doing. And what is she doing? Scrolling on her phone, which you should not be doing if you're the judge. And here's the story about her. She's been under scrutiny since July after she was caught on camera scrolling through social media and texting during the trial of a man accused in the fatal beating of a 2-year-old. She was sworn into the bench on January 9th, and now she's on paid leave. You can see what the Chief Justice of the court says there about it. She texted over 500 times during this case, and with a bailiff. And they talked about how jurors looked, why they have small hands, why was one of them wearing a wig, how great the defense attorneys were, how bad the prosecution was, that he was a bunghole, and it just constantly during a trial saying things like this and wanting to clap for the defense and can't believe the state brought this case. And I can't really imagine being more inappropriate than this. This is like the Murdaugh allegations on steroids, although she's not accused of talking to the jury, but she's the judge. What the hell is she thinking and doing there? People often use their phones inappropriately. This is a terrible example of it. Why in the hell would you have... I can't imagine being a judge and being able to pay attention to what's happening in the case, objections and things like that, because you got to know the context if you're the judge ruling on it. And then having the time to flip through this stuff and be texting somebody about it just seems crazy. I mean, when you try the case, you're either trying to make sure you're ready to answer an objection to the question you're asking, or pin the witness down if you're cross-examining, or be prepared to object to the other side. I can't imagine also checking Twitter and X or whatever they want to call it this week while I'm doing a hearsay, Your Honor. Sorry, just let me retweet this and I'll be right back with you. Yeah, no, that's misconduct. So that's terrible. So here's an example of a judge being bad. And in the YNW or whatever he is, Melly case, he's a rapper, not just at Christmas time. Okay, for gifts. This guy is one of the singing rappers. So that's cool. My wife did not like that joke. And she would do the same as the judge in this case and remove me from the bench for that misconduct. But here is a picture of the prosecutor who has been removed from the case. The judge took her off because she might be a witness, because apparently the search warrant was executed and not by the detective who had the authority to do it. And there was some discussion about the other detective saying, well, if you need me to have been there, then I was there. That's the idea. And one of the state's attorneys actually testified for the defense for that. And there's a big question about this prosecutor's involvement in that, and that she might be called as a witness if this detective is used. And so a giant mess. So now this case is due to kick off to trial in like a week or whatever. And the state has no prosecutor to use, and their detective witness will be under great fire and may have to call in a district attorney to rebut him and impeach him on his credibility. And I will say that, once you're found to have done that, if you're law enforcement, you get on this list called a Giglio list, or at least you should be put on it. You probably can't testify anywhere else either, because once you have, assuming this person did this, that, if you've engaged in dishonest conduct or solicited false testimony or try to break the law or something like that, then DAs are going to have to notify the defense if, in other cases, if this guy's going to get up and testify, because that's potentially impeachment material. And it's kind of like an extension of Brady. It's called Giglio. And that is a career harmer for sure, or at least it should be. And let's see. Yes. Somebody said, wasn't she the lead prosecutor? I think that she was. I didn't really watch that case. Now, Legal Vices has been all over this. So if you want to know great details about this, he's been ripping it up, covering this in great detail. It's quite smart, so he has good analysis on it. And I think this is about the case we just talked about a moment ago with the scrolling judge, that he got 4 years, which is time served. Yeah, I think it was like some kind of lower manslaughter thing or something like that. What was the name of the judge who scolded the defense team for misunderstanding that they were referring to her kids, and after the trial hugged the prosecutor's team? And I'm trying to remember, but there was the Florida case with the school shooter, and I can't remember her name off the top of my head, but she did do that. I think she did misunderstand that and took that too far. Obviously, she and the defense team didn't like each other by that point. And I think the defense team egged her on a lot more than I would have ever done with any judge ever, the level of disrespect. However, her responses to some of that were not like I've seen in court either. And then she did come down off the bench and hug people in it. And while she may have been willing to hug the defense team, I don't think they were interested in that. The fact she was hugging the prosecution team, shouldn't be doing that. Of course, I think she resigned, but she was facing some issues, some trouble for that. So, if you're the judge, you got to keep your cool, or you should keep your cool and deal with things the right way. And if you're the judge, you have the authority, right? So if the defense team was actually doing something that was wrong, she had the ability to deal with that without, getting all mad about it and stuff like that. You can do that without expressing a great deal of anger. I think yes. Okay. Thank you. It was a Nicholas Cruz judge. Her name was Shear or something like that. Yeah. So I think that, and I believe she resigned is also what I heard too. And her response is unprofessional. I agree with that. I mean, I've been in cases where judge have sanctioned people, and sometimes, everybody's human. You get a little exasperated and stuff like that. And I watched the DA one time tell the judge he didn't want to go get something that the judge was wanting him to get because he didn't want to leave the court. And the judge said, well, I'll watch it for you while you're gone. I also know of a case of federal court that was not me in it, but was our rival firm where they were in an informal conference, and it came out that they had not done something in discovery that this federal judge had already ordered. And the judge, who was a very nice guy, stood up without yelling at anybody and put his robe on and said, let's go get on the record. And then when he did that, he sanctioned them personally for a substantial amount of money and ordered the firm not to reimburse the attorneys involved. And there was no yelling in it. So the yelling compromises your position as a judge sometimes for the authority that you do have, which is a lot. And now we get over to Tim Ferriter. So I was kind of watching his case while we were up in the mountains a little bit there, just here and there. He needs to be tough, right? Here he is. He's got to get ready for his thug life, because he was talking to his, I guess, adopted son there about, you tough guy now. You took this bagel. You tough guy. I'm going to put you in this box. Well, you got your own box coming there, Tim. I've got some bad news for you. You're going to be sitting in it for a while. And you can see the reaction that his wife is having, I'm sure, for his behalf, but also she's facing charges. When I ran this poll on it, it was, I don't know, about 600 votes. And you can see that it was 96% guilty and 4% not guilty. And you never see a poll that's one-sided. So case was a giant loser, and he should have taken the plea bargain. Now, is the judge going to make him pay for that? He could face decades for this. The maximum sentence is quite high, but likely he's going to get years, but probably more than what he was offered on the plea bargain. His wife's trial date has not been set yet, I don't think. And the DA said, when I watched her in an interview, I think with Court TV, that they hadn't offered her a plea yet, but she would be talking with the defense. So maybe something will be offered there. Now, they may go easy on her, but if they choose not to, the state's hand is strengthened greatly by the reaction the public had to this trial and the jurors, because you have to look at this and think everybody thinks this is terrible. You're not going to get 6 or 12 people or whatever in the next jury box. And likely it's going to go, well, it's okay that you did that. That's cool. You should lock kids in the box and tell them they don't get food and mock them and be nasty to them all the time and have a camera watching them 24/7, even if they're misbehaving. I don't think it's going to work out for that. Unfortunately, he gets a toilet and not a bucket. Yeah. What do I think he's going to get? I haven't had time to really look at the sentencing guidelines down there. I think the maximum sentence is like 40 years, but there's some guidelines they have, and a presumptive sentence is 3 years. He was also, though, found guilty of more than one charge, and they could make that consecutive, concurrent, or whatever. It depends on whatever rules they have. I think he was offered a plea bargain of like a couple of years, so he's probably not going to get that. He's probably going to get more than that, I would think. But yeah, I'd seen that too, that he's facing up to 40 years, but I think it's more likely that he'll get years. But how many years? Partially is going to be based on how the judge saw that. And the judge was firmly convinced, okay, because I remember him on a motion saying, if you're trying to tell me that the jury couldn't find that this was torture and abuse of this child, and move on to your next argument, okay, because there's plenty of evidence of that. Then, of course, ultimately the jury comes back with this verdict. Now you got to go back in front of this judge, I think next month, for your sentencing. And he'll have a chance to speak on his own behalf there. He did not testify in his own defense, which is typical, and you don't have to. But and I don't know anything he said could have made a difference there. But if he doesn't talk to the judge during the sentencing, there's your last chance to influence the judge in terms of what you get. So somebody says the plea deal was 2 years and 5 years probation. Yeah. So see, I think he's going to get more than that here. So I think he gambled and he lost. And are they going to offer his wife the same sweet deal now that they know that, and everybody can see that this is an ultra slam dunk? Even with the kid getting on the stand saying, hey, I think people should move past this and stuff. Even with the kid saying that, the jury was like, nah, how about this? Why don't we move past it after we put you in the box? And then we'll all get past it. Tim, what do you think about that? Will she get the kids back if she takes a plea deal? Well, I think she's going to go to jail too. So after that, I don't know what they'll do. I don't know. But I think she's going to go to jail. I don't know if the kids would want to go back to them, would they? I don't know that either. I mean, there'd be some kind of hearing on the best interest of the child kind of stuff and all that. And depending on their ages and stuff, the judge will listen to them more or less. And then probably guardian ad litem and other social workers. And, there'll be a lot to deal with, potential visitation and stuff. And I don't think there's going to be any custody or whatever anytime soon, because I think they're going to be both in jail. So that's the Tim Ferriter situation. Yeah, I think, he hung himself with this whole Ring video thing or whatever he stuck up in the kid's room because he videoed all this stuff and he was a complete butthole to this kid. It was awful. And the defense basically was, yeah, but I mean, he was a bad kid. And I know one of the incidents was the kid tricked the teacher into thinking he could make an announcement and he used that to say something bad about his sister. If I were his parent, I would definitely have a reaction to that. But my other reaction would be, I can't believe you're able to trick him like that. How smart are you? Apparently he was also able to get into the school computers and factory reset them. Same deal. You must be punished greatly. But on the other hand, dude, how smart are you? Can you get this printer to work? Right. I mean, the kid was obviously, in my opinion, super bright. Okay. And he turned some of that toward evil, but he was in school, probably not challenged at all. It was way ahead of the game in terms of being smarter than a lot of other people there. Life dealt him some good cards and some bad cards for getting adopted in a circumstance like he was, but then getting the parents he got who wanted to put him into boxes constructed in a garage and lock him in there in the dark sometimes. So no excuse for what they did, no matter what he was doing. And I don't think what he was doing was but so bad. Like, it's not like he was trying to stab people and stuff like that. I think they just felt like they needed to come down on him and really abuse this kid. If he doesn't have a lot of psychological damage, it's a miracle. I think he is highly intelligent. Bad kid because of bad upbringing. Yeah, it's hard to know chicken or egg, but what you just said there could be correct. But on the other hand, if he was just a bad kid, it's and I'm sure you agree, there's no excuse to put him into a box. It's just, that's not going to be the answer there. It's all hard to say on that, except that no surprise that he completely lost there. And now he gets to be the tough guy and see what the box is like. And he doesn't get a bagel whenever he wants it, depending on who puts money on his commissary. And hello to Judy, who we watched some of your videos when we were out and before we went on our trip. So as she covers lots of things, but the trial that she's been covering in great detail, the Adelson trial, is heating up for trial and not looking too good for the defense, in my opinion, right now. But if you want to know more about it, which you should, because it's interesting, then catch her channel, because she's got the coverage. And there's nothing I do on this channel that's as interesting as some of the videos she puts out there. That's for sure. So, yeah. And Mrs. Southern-in-law sitting in the room, but text on here, there wasn't any display of tenderness or grace on the parents' part. And that's true. And I thought, and maybe I missed it because we were gone for some of it, that the defense would show other things and say, okay, they were mean to him sometimes, but they were nice to him a lot. And I don't know if that came really out or not. If it did, it didn't persuade anybody. I just never heard it. It sounded like they were just like prison guards with this kid in the morning and stuff. It's awful. It's hard to discipline kids nowadays. You almost need a degree in psychology. Yeah. I mean, nobody really worried about it when I was a kid, from the standpoint that if you misbehaved to a certain level, you would receive punishment for that. And your punishment would be something that you didn't want to experience. Sometimes it would be because they didn't have phones to take away that you could cry about. But what they could do was test your nerve endings on your behind and alert you to the fact that, much like you shouldn't put your hand on a hot stove, you shouldn't maybe play with matches or other things like that. And also the school might spank you, and then your mom would spank you, and then your dad would spank you, or if you misbehaved at your friend's house, they would spank you, and then you would get another spanking coming home. I'm not saying everybody should spank everybody, but let's face it, that was the general idea for disciplining kids back in the old days. Was you tap that behind. So yeah, they started corporal punishment. Yeah, so I'm not saying you should have it or you shouldn't have it or whatever. It's not a thing for that. I'm just saying it was an easy decision back then if you're going to discipline your kid, right? You could spank them or not, and you didn't have to spend much time thinking about psychology. And maybe that worked out, maybe it didn't. So yeah, he was a moron for not taking that deal. I mean, does he think everything he did was okay because his kid did some bad things? And especially with the charges he was facing, I wasn't really impressed with the defense in this case. And when they started and they were like, but this kid was bad. This kid was outsmarting people at school, and this kid wanted to eat an extra bagel. I mean, oh my God, this kid would actually sometimes, he's probably a BMI of like 1. He wants to go to a refrigerator and get a snack, and oh my God, he should be locked into a box for that. So I don't think so. Yeah, my mom did not let the school spank us. She said that was her job. Yeah, and that's also bad too, right? Because some parents are known for delivering spankings that were at different levels than others, all depending on the situation. So who knows? Who knows what all the right answers are? And over the thousands of years that people will continue to exist and have existed, things will ebb and flow. Times will change, and what are the true right answers? Tim's previous lawyers are suing him for payment. I didn't know he had another team for that. Thanks for letting me know that. So if I were these lawyers, I would want to make sure I got enough of a retainer that I wasn't uncovered too much on this case. All right. So I think we are about to the end of this. Expanded some of the cases here that didn't all involve murder. So I feel a little better about that. It's not as depressing as some of these other cases. I mean, this is terrible. Okay. This is what this guy did is terrible, but you saw from the verdict that unlike a lot of these murder cases, almost everybody agreed this guy should pay a price for what he did. And I don't, if you don't, that's okay. But I think that's a pretty easy case to say he should pay a price. Now, what that price should be remains to be seen. And the jury agreed, even though there was some shenanigans with the evidence during deliberations. So there you go. And all right. So I will say this. How's the kid doing now? Is he an adult? He's like 16. Yeah, I think his wife says she thinks he's still a teenager, a minor. And I think that's true. He did testify. And of course, they didn't show him and stuff like that. So another reason I think he probably still is a minor. He had a very flat affect when he was testifying. And he did say he didn't, he thought it was wrong what happened to him. But he also said that he thought his parents had made a mistake and he wished people would move on from that. So, and I think he admitted that he did bad things and stuff like that. So he just delivered a straight up testimony. But I thought some degree too that the flat affect he had, this guy had developed some mechanism to kind of handle what he'd been put through and was going too easy on his parents. And that's okay. Because he said it was easy for him to remember good times too. And he should, but he's not the one punishing his parents here. And it's not his fault that they're being punished. They're being punished for what they did and the fact they got caught doing it. And society is making a statement on that through the judicial system that you can't treat kids like this, buddy. This isn't, we always have the concern of is the state too involved in people's lives or whatever, but you're not free to take people that you have control over and abuse them like this. Okay. And where that line is, for some people, again, so for some people, spanking might be abuse, and some people it isn't. But as you saw from this chart that I put up with the voting, 96% of the people at least thought sticking your kid in a box that's locked, turning the light off and depriving them of food and sometimes water and having them use the bathroom in a bucket. You can't do that. It's not a fascist state, an overreach, a Nazi regime or anything like that. That's just, you're not allowed to torture kids. And that seems a very reasonable position. And I'm glad we can all agree on that. All right. So, yeah, I wonder how Ruby Frank is going to proceed. I know there's been a lot of things coming out on that case, and I just haven't had time to look at it yet. But there's another awful one. If you heard the neighbor who called in when the boy went to the house, the neighbor started crying on the phone. I mean, a grown man started crying, talking to the 911 operator about the condition of this kid. So that's ligature marks or whatever on his wrist and ankles, I think. And the kid very hungry and thirsty and stuff. And that looks really bad. I'd like to check into that one a little bit.
Any updates on Daryl Brooks?
Mrs. Southern-in-law said there's any updates on Daryl Brooks. I don't see that one, but I missed some things. And now when I checked the docket, I didn't see anything on the civil case, which I don't really think he's going to participate much in, but you never know with that whack job. But his time is coming when the court is due an update on his counsel. And that's what I was checking to see if anybody had been appointed yet that had shown up and made an appearance, and I haven't seen that yet. Maybe that'll just happen at the hearing, or maybe we'll find out that he doesn't want any of those people and he wants to go pro se, which is still a lot of people's bet. And it's what I thought he was angling at because of his desire to cross-examine Erica, but we'll see. Ruby's so despicable. I saw some of her old video footage and she seemed so narcissistic. Agree with all that. And then she got up with this other woman. And I think probably then things took a turn for the worse, unfortunately. All you can say on that one is thank God that, the kids have made it out. But a lot of family members there talking about the trauma that they've gone through and all that. So, yes, I apologize. I said that he might go pro se, but pro per is how Daryl prefers to refer to himself, as a sovereign loser. All right. Erica did a video last week that she's doing good. Glad to hear that. I haven't seen it, but she's been pretty strong through all this. And I think Brooks has miscalculated on the strength that she either had or has developed, and his hideous desire to blame her or basically any woman for all problems he has in his life. And it seems some of his family members support him in that belief. There's another reprehensible thing about him in the long list of, he's like a black hole of evilness, right? Like it just sucks in anything that he can, and it becomes a black hole of just absolute nonsense badness. He doesn't exude anything that's good, even though he had that weird reverse charisma that like you hated this guy, but you wanted to watch the trial of him and see what dumb, stupid thing was he going to say next. Yeah. They reinforced each other's sadism, Jody and Ruby. And I think there is that element. Yeah, I agree. Again, I don't know much about the case other than what we've seen so far. I haven't read any of the documents about anything that's going on, but and I always like to try to do that. But that's definitely my impression. And you've probably seen more of it than I have, but even from what I've seen, I'm agreeing with you. Yeah, say that comment. I won't pop that one up, but I did. But I did see it. All right. So yeah, yes, Erica is on YouTube. She has her own channel. So if you want to hear straight from her mouth about how she's doing, then definitely do that. And if I ever call her Erica Brooks, and feel free to call me out on that, because I have done it before and I don't mean to. All right. Certainly don't mean to put that on her, but she does have her own channel. Yeah. Last time I checked on Murdaugh, and I haven't checked in the last couple of days, I hadn't seen the Court of Appeals do anything. They had, the last time I looked at it, they had sent his team when his team filed that extra document showing the affidavit of the guy who said, yeah, I posted this thing about, I'm sorry I posted that and all that. The court said, hey, great for filing it. If you want us to do something with it, you actually have to file something else, because Court of Appeals is very technical, more so than trial court. But I don't know anything else that's going on with that weirdo, other than, as far as I know, I'm about the only lawyer that I talk to who thinks he actually did it. And whenever I'm on any panels, I'm the lone wolf on that one. Am I right or wrong? I can't really say, but I think that he did do it. But I respect the position that people can have that, well, maybe he did do it, but it wasn't, the evidence didn't show that beyond a reasonable doubt. I hear you on that. And even if you think he didn't do it, I hear you on that. I'm just talking about my opinion. A new Murdaugh movie. Man, there's a bunch of those, aren't there, right? Which is kind of weird, because it's kind of like the Depp Heard case. Why do you need a movie of it? Because you can watch that case, and that case was interesting to watch, right? With the real people in it who are themselves actors. So it's kind of strange to do that. And to me, a little bit like Murdaugh, maybe you can inform some by having it turn into a movie and stuff at this phase, but it's like it's still evolving. This case is still in progress. I guess I got to strike while the iron is hot. Now, speaking of that, we watched Making a Murderer back when it came out. And I'm going to admit right here that when I watched it, I became more and more outraged at the injustice that this guy suffered. It's just a fever pitch. I was furious, ready to go up there and work profane for this guy. But I did what I usually do, which is at the end of it, I'm like, but still, that's somebody's viewpoint. And it didn't take me very long at all looking into that to find out they had misrepresented several material points in that documentary. Yet they had people at a fever pitch believing this guy was innocent and believing there was a great injustice currently going on. And that wasn't really the case there. And the production value of making a murder was fantastic. They just did a great job at telling their story, but it was a story. It wasn't a documentary at all. And so they were watching the counter documentary to that, which is based on showing how they edited courtroom testimony to make it appear answers to questions were different than they were because they take an answer to some other question and superimpose it here. I mean, you can't go through the list of things there in any short period of time of how that that documentary show misrepresented what was actually going on in that case. Very interesting. So I think, it's terrible to have done that because lost in all that was the victim. But I didn't believe some of the conspiracy stuff that was in it, but like some of the stuff I didn't know enough about, like the blood thing and stuff. I'm like, oh my God, I can't believe they might have done that. But then you find out none of that stuff happened. So he killed her after assaulting her, and he's in jail for it. And that's where he needs to be. Yeah, I'm seeing some of these comments now about other kids being traumatized. It's awful. And, it weaves into the fabric of your life, right? And it's going to be a part of you, whether you go to therapy or you don't go to therapy. You are, to some degree, the sum of your experiences. What is you encapsulate that, and it's never really gone. So that's one of the reasons that I hate that so much for people that treat children poorly like that in a variety of ways. They're affecting that person's for the rest of their life, and usually for their own selfish reasons to do it. So refuse to watch any of those true crime documentaries. I can't say I'm such a purist as that. And I hear you on that, because we do watch Dateline. Yeah, there's some laughing in the background there. Watch Dateline and some other ones and stuff like that. Yeah, I will say this. You think you're talking about Brendan Dassey there. I still can't see how the kid is being all wrapped up into making a murderer thing. Even watching the counter side to Making a Murderer, the interrogation of Brendan, whether he's involved in it or not, it's often, to me, so many leading questions with almost no answers, or just yes or no or whatever. I don't accredit what he says to a great deal. And I don't think he would have ever engaged in anything like that if he did, absent being maneuvered into it by somebody. So that's terrible. Yeah, we did watch the documentary about to take care of Maya. And I would say that I think it's not it definitely takes a position, right? But it's not maybe as bad as some things you'll see in terms of that. But I hear you on the evidence part. And I mean, hey, the trial's on right now. So you got some opinions on that one, on how I've seen the plaintiff side wrap out, although I think they've picked up some speed toward the end of this, is my understanding. And I saw Law and Lumber put a tweet up about a jury question saying, basically, could Maya's inability to be married later, or reticence to that, or to have kids, or to take her kids to a hospital, or to be denied these experiences be part of the worth of what her case is? And if you're the defense side, that's not a question you want to hear from the jury at all. Like, hey, I'm thinking of more ways that she could be entitled to money. Can I think of those ways, Judge? That's, if you're the plaintiff side, you're like, hell yeah. And if you're the defense side, maybe you want to reevaluate your last settlement offer to the plaintiff, because this case could go badly for them with a question like that. I mean, probably there have been settlement discussions, and sometimes cases settle right in the middle of trial, and sometimes while the jury is out deliberating, have a civil case, and they'll settle it anyway, because you should, if you're responsible on both sides of it, assuming you've been talking about settlement, evaluate how the case is going and how you think the jury is reacting to this. And it's a civil case, so if you can bring it to a conclusion, you'd like to. It'd be interesting to see if they ride this one all the way to the mat. All right. Jury's on point with some of their questions. Somebody says that's the only one that I've seen. and she's a professional patient. Maybe. And, the problem with that is I haven't seen a lot of it. I saw some of the early parts of the trial that I wasn't excited about from the plaintiff side. I'm going to have to tell you, from the presentation standpoint. And I'm like, but I have to believe they gained some steam and got some good stuff in for the jury to be asking questions like that. Miss Sutherland talking the background because the medical side is her side. I think the hospital tried and the family wanted them exposed. It possibly. I would say, generally speaking, even in big cases like that, ultimately the goal is you want to, settlement, because that's what several civil cases are about. Not always. Sometimes it is the principle of the thing and stuff like that. But if there are large settlements, sometimes it comes with, some soothing things about, like, we're changing this procedure, we're doing this and that, we're really sorry that this happened, and things like that. And you can believe that more when the number sign is closer to what you want than if it's not. I mean, I've seen a lot of cases settled that you would think wouldn't because of the behavior on both sides. And settling a case is good because you get to stop doing it. You don't have to deal with appeals and all of those things like that. So, but they're getting close to the end of this one. So if I were the defense and I saw questions like that, I might want to reevaluate where I stand on my settlement posture. And hospitals don't like to be in courtrooms and trials and things, and doctors don't like it either. That's not where they want to be. They settle cases a lot, but here, of course, the demand is for so much money, but the consequences are quite high, because to the degree that they contributed to the mother's suicide, that puts at issue there. If the jury believes that story, that narrative, that the hospital caused that, you could see the hospital being exposed to a great deal of money for everybody on the plaintiff side. So, I don't know how it's going to go out. I need to see more of it. I think maybe some of the recaps that have been done. All right. Well, I appreciate everybody commenting all that. I think we're getting close to the end. And we did that slide. So what I will say is I played the traditional opening to the weekly docket on this. I'm going to refresh that one soon. And I mentioned that we had people from all over the world, and we love different accents other than ones we have. So this is an invitation. If you want to be the voiceover for the intro that's coming up, then send me an email with the audio at Southern Law, letters YT, southernlawyt@gmail.com. Or if you can post a YouTube video in private or whatever and send me the link to it and make an intro. I'll put it into the intro that I'm going to do. Hey guys, welcome to the weekly docket, or a crime case update, or anything you want to say, because I know there's some cool accents out there. Not going to lie, I'd like to see one from Scotland, but there's some other good ones too. If you don't want to do it, that's fine too, but I'm going to work on that soon, because I've been milking that intro for a long time. And at least criminal cases take a long time, so the pictures I'm using are still relevant. But it's time to move on from that. So if anybody wants to do that, shoot me something, and I will, and where you're from, and I will see if I can get it incorporated into it. And here's Mrs. Southern Law saying, please send, because she'd like to hear something other than me opening the show. And I can't convince her to do it, at least not yet. But I bet she will if some other people volunteer to as well, because she does not sound like me. All right, let's see. I appreciate everybody tuning in on, even though some of you are in sunny environs. We're not, and it's a dreary day here in Raleigh, but it's good to catch up and talk a little bit after coming back from the very interesting Smoky Mountains, where we did not encounter any bears, but we did get some blue sky up there and we're able to see all the scenery. It's a very nice place to be. Good set of mountains here in North Carolina to get ready for the winter climbing season and see just how far we are from the goal where we need to be. Video backgrounds now supported. So I'm getting an announcement from the software. Anyway, thanks everybody. We really appreciate it. Speaking on behalf of myself and Mrs. Southern Law, and thanks. Bye.